Hello, good morning, everyone. Good afternoon for those who are attending this webinar, not from Brazil. And first of all, this is the final session on the webinar series on the accession of Brazil to GPA rules. Many issues were discussed and many ideas were exchanged. Important topics were addressed, creating an important network of scholars and specialists interested in the theme. This is the 11th webinar on the theme, and EDP and University of Nottingham initiative pioneered the discussions on the theme of Brazil process of a section to the GPA. There is an important information that's relevant to all that are attending to our session today. That is that the Foreign Trade Secretariat of the Brazilian Ministry of the Economy issued a notice number 55, opening public consultations on the accession of Brazil to the GPA rules. This is an important opportunity for everyone to make opinions and make some contribution to this discussion. And this notice of open this public consultation for 60 days, and it will end on 22nd of October. The discussions and materials that resulted from all the discussions on these 11 webinars certainly will be very useful to the consultations and will be very useful for all the interested parties on the themes. It's essential also to thank all the previous and the current panelists for generosity in sharing their knowledge and giving part of their time to share ideas and to participate of this final session. And make this initial statement. I'm very honored to present Professor Sue Arrowsmith, who is Professor Emerita of the University of Nottingham. She's the author and editor of many books on public procurement, including 2 books on WTO GPA public procurement rules. She have with Steve Schooner, that is also our panelist today, presented at many WTO Academy programs. She's the editor of the International Journal of Public Procurement Law Review, and in 2009 she set up the distance learning program on the international public procurement at the University of Nottingham. And with this, I pass the word to Professor Sue Arrowsmith.
Thank you very much. Okay. Thank you very much for that introduction. So the topic today is enforcement and remedies. Very sad we come to the final event. I can't cover the whole topic obviously in just 15 minutes. So what I'm going to do is focus on one of the topics that is key to everything and has attracted a lot of interest, which is basically the design of procurement review bodies. What are the GPA requirements and what lessons can we learn, good or bad, from the EU experience of doing similar things? Before I get into the second, into the topic, I've just got a slide. If anybody, because we are in the final seminar, if anybody's been really gripped by this and wants to follow this stuff up in more detail and study international procurement systems and different ways of doing things, this is the part-time distance learning program with optional seminars, which I would say are face-to-face, but at the moment that's not, but hopefully in the future that will be resurrected. So if anybody's interested, there's the email address if you want to find out more information about this program. So the GPA requirements on review bodies, the GPA, like most international templates on procurement, has a requirement that you have to have some kind of review body, an independent review body, so that suppliers, if they feel there's been a breach of the legal rules, can actually have a forum to go to get the case looked at and to get remedies if indeed there has been a breach. And so the GPA sets requirements for that so that the GPA rules can be enforced in the relevant countries. It doesn't set, a single, as with all the aspects of the GPA, it doesn't set a single system for everybody. It just sets certain minimum standards. And there's quite a lot of flexibility in the design of review bodies to take account of fact that different countries have very different traditions and systems. So, I mean, an obvious difference is that some countries have special administrative courts where they might want to send this kind of case, whereas others don't. So it gives a lot of flexibility, as indeed with all aspects of the GPA rules. So in terms of the minimum standards, there are three basic things. Well, I'm going to just run through each of them in a minute. One is that the body has to be independent from the procuring entity. The second is it has to be impartial. And the third is that the review body or an appeal body has to have a judicial type process, so that somewhere in the system you have access to judicial type procedures to look at your case. I should also mention there's a fourth requirement that isn't actually in the GPA, but which will apply, which is that the United Nations Convention Against Corruption, which many countries have obviously party to, also requires an appeal stage for public procurement cases. So you have to have a first instance stage and the possibility of an appeal. So I mention that even though it's not in the GPA itself. So the first requirement, independent from procuring entities, what this says is that you must have, a review body that is independent of the procuring entity to receive and review a challenge. So what that could be, it obviously could be a court, a general court like we have in the UK. Our High Court deals with civil cases, administrative cases, commercial cases, all sorts of different cases, and that's the body that generally deals with procurement review as well. It could be an administrative court. Obviously, many countries with a civil law tradition have separate administrative courts to deal with these kind of actions. Or it could be a specialist court or tribunal within the judicial system devoted to procurement or to procurement and related matters. Or very importantly, it could be a specialist body within the administration itself. And that's very important. The GPA says the body has to be independent of the procuring entity, but it doesn't necessarily have to be independent of the administration. So it can be a part of the administration. And you don't need the full kind of safeguards, therefore, that you have in judicial systems for the judiciary, such as life tenure of the judges, as long as it's adequate to be independent of the procuring entity itself. So that's the basic standard of independence. What obviously that means we can debate, and the GPA doesn't clarify it, but it does make it clear it doesn't have to meet the kind of expected standards of a fully judicial type body. One comment I would just make on that, it's perfectly okay to have a review before the procuring entity itself as a first step. And this is something you find traditionally in a lot of administrative law type systems. The very first step is to take your complaint to the procuring entity, and they will give some kind of formal decision. They will look at it again, and usually that will be not to the individual or panel that made the first decision, but to the head of the agency or to a superior, a supervisor within the agency. And so you can do that, that's fine, and I'll say a bit more about that later, but you can't have that as your sole redress. You then would have to have a second step where if you weren't happy with the decision, you could take that further to an independent body outside the agency. Impartiality can deal with that one very quickly. What that means in the GPA is essentially freedom from bias, from things like personal interest or family interest. You can't have the judge having a personal financial stake in the company that's bringing the case. That's obvious with any independent type system. And then the third requirement is that you have to have either with that review body or with an appeal body, certain judicial type procedures which are listed in the GPA. So, for example, the participants have to have a right to be heard and represented and accompanied to a hearing. They have to, the review body has to make its decisions in a timely fashion in writing and with an explanation. So it has to give reasons for why it's come to that conclusion. I'm not going to go through all of those. I would flag up that with the issue of a public hearing and witnesses, you don't have to have an automatic right to that. That can be at the discretion of the review body. So you can have a system where calling witnesses is actually exceptional and only done in particularly justified cases. But the other things, they have to be there as part of that system. So just to whiz through quickly a few examples of how you could do this. There's obviously many ways you could set up such a system. So a traditional approach in an administrative law country would often be to have a sort of formal review before the procuring entity with, set deadlines for them to respond. That either might be a required step for a supplier or an optional one if the supplier feels that it's useful. Then you would have a second stage where if you weren't happy with that, you could go to a review body within the administration or an administrative court. And then perhaps, if you didn't have a court at that second level, you might have an appeal on points of law to a court. Another way you could do it is just start with a specialist independent body within the administration as a kind of quick review process, and then have an appeal to a specialist body which was more judicial in nature. And that could be useful because you might dispose of a lot of cases very quickly before the independent body without complex procedures, and just the more difficult ones would end up going on to a specialist body. Or again, and this is really a traditional administrative law type approach, you could have the administrative court judging on these cases. And that's what a lot of countries have traditionally had in procurement. Then an administrative appeal court as the second stage, and then a supreme administrative court as the third stage. So these are just, there's, there are endless permutations. I'm just giving you a few examples of how you might structure things. An important point to make is the GPA does allow you to split different remedies and review between different bodies. So quite often you might have a review body, an administrative type review body, deciding whether they should set aside decisions or just the decision itself, like to exclude a supplier or not to award it a contract. But you would have a court if you had to go to the court for damages. So if the court decided, well, this is too urgent, we can't set aside the actual award decision itself, then you might have to fall back on a court to award damages. But those two things might be split between different bodies. So what have we learned from the EU about this kind of thing? The EU has a common framework for all its member states in this directive 89665, which is actually, the GPA applies to the EU member states. So the remedies system in the EU is intended to comply with the GPA. But it's actually more detailed and more robust than the GPA. So for all the member states, the EU restricts what they can do. Just to give you an example, in the case of damages, the GPA allows you to limit damages to costs and not give damages for lost profits, whereas the EU law insists that member states have to have a debt remedy for lost profits. So it's basically a more stringent version of the GPA. But it still gives member states a lot of flexibility over the design of the review bodies. Obviously, I'm going to do a very quick whiz through. If you want more information, here's a reference to a report that the European Commission did in 2017, looking at the systems in all the different member states and the UK, which is no longer a member state. And interestingly, the conclusion of that report, the Commission concluded after that report that actually they didn't want to change the rules on remedies and so on. What they wanted to do is focus on getting member states to improve their first instance review bodies, to make them better, more rapid, not to actually change the legal rules on remedies. So it's interesting that this has been a focus of trying to improve the EU system. So in terms of procuring entity review, you know, this stage that some systems have where you can go to the procuring entity itself and have a kind of formal process for them to look at it again, usually very, very quickly. It can be a very good system in our experience, provided it does operate quickly and it's done in good faith. So, you know, you have that is the issue. Some countries, that it's simply been, you know, you have 20 days for this to happen and the procuring entity ignores it. So all it does is delay everything for 20 days. On the other hand, if you have a rapid process that the procuring entity takes seriously and looks at quickly, it can actually be very effective to resolve cases. So it all depends on how it's operated. Now, the UNtitled model law, when it was revised in 2011, decided this shouldn't be compulsory. They put that stage in, but said it should be optional for the supplier because of the experience that in a lot of countries, it did simply lead to delay. It wasn't taken seriously. Suppliers didn't get satisfactory decisions, and it just led to delay with no benefits. But the EU, like the GPA, does allow you to make it compulsory. Okay, and it is used in some member states. The 2017 report found that 6 member states actually had a compulsory procuring entity review as the first step. So suppliers had to use that stage. But, and this is very important, if you do have that kind of system, you have to automatically suspend the whole process or the award while the procuring entity is looking at it. So you can't use the procuring entity review as a way to just simply delay the supplier's remedy. The procuring entity can't go ahead and award the contract until that review's been completed. So there's an incentive there clearly to do it quickly and effectively. Otherwise it just holds things up. And it can work very well. And I give you the example of Slovenia as a country where they do have this. It's compulsory and they've had it for a while. And it has worked to resolve cases quickly so that they don't need to even go on to an independent review forum. Okay, but obviously the stage that you have to have is the independent review forum. So let's move on to that. And the important point about the EU is that a lot of them now have specialist review bodies. 15 of the 28 that were members in 2017 had a specialist review body rather than using a court. And we've seen a big movement over time from using the courts to using these kinds of specialist bodies in these countries, because experience has shown that it's greatly preferable for an effective remedy. It's faster, which obviously benefits not just the supplier, but the procuring entity. And so the European Commission now, as I said, it's been encouraging more effective first instance review and encouraging the creation of these specialist bodies. Many reasons, as I've said, you often get better expertise because the judges are particularly chosen for expertise, or at least rapidly acquire it. These bodies tend to be designed specifically for procurement. If you start off with a court system and try and adapt it to procurement, it's not tended to be very successful. So it's designed for procurement, and you tend to start and design it effectively so that you set up an entirely new approach that tries to look at cases very quickly and give remedies before the contract's awarded. Another benefit is that the rules are clear. If you give, say, the right of damages in procurement to the courts, they tend to use the rules they've always had, maybe a bit adapted. No one's quite sure how they apply to procurement. Whereas if you set up a new system, you do tend to be more precise about how it's going to operate. And they tend to be better resourced. They tend to be set up in such a way that they're designed to operate quickly. If you put things into an established court system, they tend to just take the same amount of time as other cases often, which is often too long for procurement. Speed is really important to get effective remedies in procurement. So there's a lot of advantages and a lot of reasons that these systems have worked much better than the courts. Now, in the EU, as the GPA, you can split remedies between different bodies. And we've had some cases where they've been split between these specialist bodies, but damages is still for the courts, or setting aside concluded contracts is still for the courts. 9 member states in 2017 had this kind of split. Sum up, this is a bad idea. Countries that did that, it tended to be, you know, more expensive, more cumbersome, more time consuming, obviously, from having to go to 2 separate places, which is not satisfactory for everybody. So again, I think that's something to be avoided. Although it kind of fits the traditions of many countries, it's not a very good idea. Another point which I think is very, very important about independent review, which you find in the UNTITLed model law, but not the GPA and EU rules, is to set a specific time limit or target for cases to be completed. I think this is really, really important to actually move through them sufficiently quickly. 16 of the 28 EU member states had those kind of limits. And as you'll see from the slide, 30 days was a kind of standard approach. So that suggests that you can generally do these cases in 30 days. It's happening in a lot of EU countries. 4 had a longer period, others had a shorter period. But that included, say, Slovenia, where they've already have a compulsory procuring entity review. So overall, the period is longer than it looks, although not very long. So that's the kind of approach that countries have moved towards over the years. And then a final point I would make is that we still do, in the EU does still have, I say we, sorry, the UK is no longer a member, but I'm still in the habit of saying that. Wishful thinking, maybe. Countries that do end up getting stuck with a court system, we've found sort of other procedures evolving around that to try and give some kind of alternative. So like the Norwegian Complaints Board, there's an ombudsman's sort of panel system in the Netherlands, where you have this kind of informal, not necessarily legally binding in the same way, a system for suppliers to go to and get their cases resolved, which effectively operates as the dispute settlement system, outside a sort of more cumbersome court structure. But there's no need for anything like that if you have a swift, effective tribunal type system. Okay, so, you know, just the final slide. There we go. There, I won't go through them. I'm conscious of shortage of time. But there is the, you know, there are the list of the lessons which I've gone through and which I think we can draw out from the EU's experience of operating these kind of systems. So thank you very much. Look forward to your questions later.
Thank you very much, Professor Sue Arrowsmith. Your overview on the EU situation on the different approaches are very rich, and I immediately pass the word to Professor Stephen Schooner, that is professor of the law faculty of George Washington University, and he will comment about the related US experience on implementing GPA rules. This is a different view from Europe that is important to know in order to compare the experiences. Professor Stephen?
All right, I believe I'm unmuted now, so let me first say I'm ecstatic to be involved in another one of these webinars. I'll also be perfectly clear, I'd much rather be in Brazil right now, but I realize we can't have everything. Now, let me just say a couple other things. First, it's much easier for me following Sue because she's built so much of the framework. So I'm not going to rehash that information. I'm going to just try to supplement it with some different perspectives. Let me also suggest that while I'm going to talk about a small number of slides, I've provided a very large catalog of slides if you're interested in more of this information, and we may come to some of these issues during the questions and answers. But again, my goal here is mostly to broaden and supplement the points that Sue made. But I also want to broaden the topic just a little bit, particularly since this is the last seminar in this series. And I want to think a little bit more broadly about what we mean when we talk about oversight, enforcement, and compliance in terms of ensuring that, and this is very important, the reason that countries or states do procurement is to obtain the goods or the services or the works they need to govern. Our systems have to focus on the procurement outcomes and not merely the process. So that's going to be one of my key themes here. Now, again, a broad number of topics, but to the point that Sue began with, I can't encourage you enough to go to some of those web pages that Sue mentioned, because what's happening in the European Union right now is an exquisite laboratory in comparing and contrasting how to approach these problems. So we've been doing what you might call remedies or challenges or protests in the United States for many years, and I'll talk about that in a moment. But what you have in Europe is a number of states following the WTO GPA rubric and experimenting and doing things a little bit differently. And then they're collecting their experiences and comparing and contrasting them. So you can, in effect, it's like looking at a menu. I like a little bit of this, I like a little bit of that. So sure, look at the United States experience. But again, what's happening in the European Union is fascinating to watch in this space. But the other thing that I really want to talk about today is to make sure you're thinking proactively about what happens after the contract is awarded. Post-award or after-award contract management historically is understaffed, misunderstood, underappreciated, and poorly prioritized around the world. And so I'm going to spend a few moments on that as well. I also have a number of supplemental slides, but I don't have time to talk about them today, on data-driven decision-making. And here, I can't encourage you enough to collect meaningful data, not just the data that's easy to measure, but the data that matters. And I believe that when you hear from Lindsey a little bit later, the open contracting platform is a massive step in the right direction. But again, there's data that's easy to collect, and there's data that tells you about your procurement outcomes. And the latter is much harder to do. I also just want to make two more points briefly, and that is the rules in procurement are the easiest things to agree on. The biggest challenge is going to be people and professionalization. Similar to corruption control, this is going to be the dominant issue that will determine whether you succeed or fail in the long run, regardless of what happens with the GPA. So I just encourage you to keep that in the back of your mind. Now, Sue was speaking about protests or challenges or remedies, and the United States system is frequently studied simply because we've been doing it for a long time. We're a large, complicated, litigious society, and frankly, every imaginable mistake that can be made, we've already made. So you can learn from us, hopefully in a proactive way. But keep in mind, we have a very, very highly developed and complex legal regime. But one of the complexities in the United States, which I do not necessarily recommend, is that we have a central and federal system, and then 50 separate state systems, and innumerable municipal systems and regional systems. The EU model has a fair amount of independence, but is far more driven or centered on a common core. So you may want to think about this centralization versus decentralization model as well. Now, in terms of our challenge regime, we've been doing this for a long time. We have a lot of history. Our system is heavily studied. Our system is compliant with the WTO GPA. And as a general rule, there are some interesting things you can learn from it. But the biggest thing to keep in mind in the United States system is that we made a decision a long time ago to have 3 different options. May I suggest to you that's too many, okay? It's tremendously inefficient, but it's interesting as a case study. We have an administrative tribunal where protesters or disappointed offers can go directly to the contracting agency. This is highly ineffective, although it is somewhat efficient for what we call friendly protests. When people see errors early in a solicitation, it's very easy to correct them. We also have judicial challenges. These are expensive, time-consuming, inefficient, and largely unhelpful, which is why statistically or empirically, they are very, very rare. But we have that option available. Our most popular remedy, however, is found in a quasi-judicial but administrative tribunal known as the GAO, or the Government Accountability Office. I primarily mention the Government Accountability Office because it is highly transparent and has tremendous models for procedural regularity, for transparency, and for involvement by even the least sophisticated players. Okay, now, as you think about all of these issues, however, I want to change gears just for a moment, because in order to have a meaningful protest or challenge or remedy system, it only works if the marketplace and the public has confidence in it. In other words, what we've seen around the world is in states that don't have respect for the rule of law, there's no reason to expect the marketplace to rely on these systems. Similarly, and maybe even more important, it's incredibly important for all of the players to respect the tribunals, or they frankly have no credibility. Another thing culturally that's often difficult to deal with is people are afraid to sue or challenge or enter into conflict with their prospective customers. And so it's imperative for the government to convince the marketplace that if you bring these challenges, you will not be punished in the future. And often that's quite difficult. But I can't emphasize enough one of the points that Sue made, and that is that these tribunals only work if they are experienced, knowledgeable, credible, and independent. In other words, just because these systems could be operated by judges doesn't mean they're going to work if the judges don't understand the nuances of your procurement system, if they don't understand the business model. So what we've seen around the world is the best system are staffed by experts who are given independence and authority. And that's going to be one of your biggest challenges. But I encourage you to look at those models as you look around the world to see what's working and what isn't. But the last point I want to make on this is in the protest or the challenges or the litigation themselves, it is imperative for the government, the ones defending the agency action, to show respect for the system. Because if the private sector sees that the government doesn't respect the system over time cannot succeed. Now, I want to change gears and just very, very briefly again, go back to the point I was making earlier, that as important as these GPA requirements are, the single biggest hole in the World Trade Organization government procurement agreement is what happens after the contract is awarded. In the United States, we think of our procurement system, as we say, from cradle to grave, from requirements definition to acquisition planning to competition to contract award to performance of the contract to quality control to payment and closeout. My personal belief is if you convince yourself that procurement under the GPA definition means that when you've awarded a contract, you've succeeded, then frankly, I think you're making a big mistake. So along those lines, very briefly, awarding a contract is the beginning of a relationship, just like a marriage. If you spent your whole life preparing for your wedding and you declared victory on that day, you're not prepared to make the compromises necessary to have a successful relationship in the long term. So it's incredibly important to keep in mind that you need to proactively think about managing that relationship to ensure you get the outcomes you need. Now, self-help is not a good solution here. So what we need is better thinking about how we're going to staff the relationship after the contract is awarded and what we're going to do to ensure that when problems arise, we have solutions to those problems that the parties understand at the time they enter into the contract. In the United States, we have a model where we have a massive suite or collection of what we call remedy granting clauses. So in other words, offerers know that when they do business with the government, there are standard terms and conditions that anticipate almost anything that can happen, anything that could go wrong during a government contract. And therefore, based on that information, they can assess their risk and they can price their contracts accordingly. And we've literally tried to deal with every imaginable circumstance in these remedy granting clauses. And when I say remedy granting clause, I'm talking about specific language that goes into every government contract that basically says, if this contingency or problem or issue arises, here's the way we're going to behave. One of us has a duty to give notice to the other. We're going to work out the problem this way. We're going to allocate the economic risk this way or that way. And if necessary, we'll then open the door to a dispute system where the government has waived its sovereign immunity, much as we do with regard to protests regarding the award of the contract. Now, again, I've spoken quickly, and these are massive issues. And as I mentioned earlier, there are dozens of supplemental slides. But if you only remember one thing that I've said in this particular webinar, in the last of these webinars, it's that in order to deal with the World Trade Organization and get accession to the GPA, you have to focus on your procurement procedures. But in the long run, our procurement systems only succeed if we focus on procurement outcomes on a contract by contract basis. Did I get value for money? Did the customer or the program manager or the ministry or the agency get what they need? Those are the outcomes that matter. What we need to do is design processes to ensure good outcomes, not focus exclusively on process for the sake of process. Again, it was a wonderful opportunity to speak with all of you.
Thank you, Professor Stephen. It was a great speak, and the experience of the US is very rich and very important in order to evaluate all the options that the Brazilian system will have, and even have to adapt in order to get the GPA rules correctly enforced here in the Brazilian territory. And for this evaluation, evaluations under the lenses of Brazilian law and Brazilian legal experience, I will pass the word for Professor Juliana Bonacorsi de Palma, that is professor of FGV in São Paulo and University São Judas Tadeu, and she is master and doctor for the University of São Paulo, a master for the Master of Law by Yale Law School, and former visiting scholar at Washington College of Law, American University. And she's also coordinator of the public group Center of Research on Public Law at the FGV University. And Professor Juliana, please.
Thank you very much, André. It's a great pleasure to be here today, and I'm extremely honored to make part of this final panel. First of all, I'd like to congratulate Cesar for this journey. I mean, you made something extraordinary to Brazil, so congratulations. Also to Marchessault Filho, and for my colleagues on this panel, Professor Sue, Arrowsmith, Stephen Schooner, and Lindsey. So thank you very much. What I want to do here today is to bring the Brazilian perspective and first reflections on how to design this review body that is so well discussed on this morning panel, okay? So first of all, my main point here is that this is not an international debate. Brazil now has an ongoing agenda of administrative reform and public procurement reform in such terms that we should also take this moment as an opportunity to review our bases and maybe advance on domestic public procurement reform. So that's my main point here today. We need to have this moment as an opportunity for reflection and reforms, and the necessary reforms here in Brazil. And these reforms are going towards to legal certainty. I'm going to explain this a little bit better by a case from Brazilian perspective. Introduction of more effective tools to reduce corruption. So I'm not going to let this to the end. I'm going to say right now, we need to have whistleblowing programs on public procurement. So it's a shame we don't have this kind of institution that's so effective to get acknowledgement of cartels and also many other frauds involving public procurements. And also a change of mindset regarding how we deal with the deterrence. So we are all about punitive sanctions and penalties. In my experience, this is not what you need to seek. And sometimes we want to change law, but change law is not something effective. So maybe if we get the experience of the reverse action, which is pegão, we are going to recall that on 1990s, we had this well-insulated on Anatel, the telecommunications agency in Brazil. And because it was so well succeed, all public administration wanted to deal with this specific kind of public procurement. So the substantial change came on practice and not on the change of law. So this is something that we need to have in mind also on this reform, okay? So this is basically corruption scheme in Brazil. I'm not saying that it is the car wash scheme, but it's something approachable. What I want to say is that we have a lot of features on Brazil, and we need to tackle these features, considering not only our legal culture, but also how these procurements are being taken on Brazil. So first, taking the example of this entity, this SOE company, and any public administration agency that's supposed to go on public procurement. So the heads of this institution are appointed by the president. And I'm going to talk about this chapter on the federal level. And I'm not accusing anybody. I'm just describing a scheme. I'm totally on an academic perspective. It's important, guys. I'm going to take a lot of risks today because I truly believe this is a very important moment. I'm going to put my opinion, and I'm going to be, unfortunately, a little bit confident on my affirmatives, but I think that it's what Brazil needs right now, okay? So the heads are appointed by the president. What's the importance of that? These heads, these people are going to design, to model the tender terms, okay? So this is something peculiar in Brazil. We have this fragmented modeling public procurements, and we don't have a specialized body to help us think out these tender terms. And why the president makes such appointments? Because these appointments come from political parties. So basically, they seek voters. They seek money for financial campaign. And the president gets advantage on that because his or her bills are going to be well addressed on Congress. So president needs to get a majority on Congress. We have this coalition system in Brazil. And this is unfortunately a way to get this coalition, not by ideas, but basically trading positions, public positions with these appointments, okay, appointment and support on Congress. Therefore, on the bottom side of this slide, you can see a cartel. So a bunch of companies that is the term is special rules. And it's interesting because that's the engineer that provides an overpriced contract. So this contract is overpriced. And by the time you have this overpriced, you can see this scheme going on. And if you follow the money, you can get to issues we need to address. So I'm going to talk specifically on cartel. So what are the Brazilian institutions aimed at investigating this kind of problem, the cartel fraud? A lot of institutions. That's something so Brazilian, okay? So antitrust institution in Brazil, the Antitrust Authority, the Federal Audit Court, as soon as I'm talking about the federal level, so this is Audit Court, okay? Also, the Office of the Federal Controller General. It's an internal agency on public administration on the federal level aimed at investigating and combat corruption. Why not to say federal prosecutors? And how about federal police? And also for the Federal Council. So we have a lot of institutions here. They are competing for a space. They are, let's say, they are struggling for power. I mean, this is my perspective. People may say it's a fraud, or people from abroad, respectful academics may say that it's interesting because in Brazil we have this huge problem with corruption. Therefore, a lot of people and organizations taking hand off this issue is beneficial for the system. I think we have a huge problem on coordination. And for Brazil to access to GPA, it's fundamentally important to have the homework made. And you need to deal with this problem of coordination. And especially if you consider that we have institutions that have constitutional clauses. So if you just have a law saying that the competence is of this institution, of this review body, for instance, maybe federal prosecutors, maybe audit controllers are going to say that this law does not bind because their competence derives from the Constitution. So in Brazil, things are harder. If we need this independent body, independent review body, we need maybe to change the Constitution. Therefore, we have all these monitoring institutions. We cannot just get rid of these monitoring institutions and create a brand new and say that nowadays, from now on, we are going to deal only with these institutions. It's inconceivable, in my opinion, and it's naive. We need to get an institution that's capable of represent all of other institutions. Okay, and also we need to tackle this issue that I say we have this huge correlation of enforcement with command and control, and we structure our enforcement on that terms-based regulation. So basically, I'm talking about punishments and sanctions addressed to public servants, and they get totally afraid to make innovation and take creative alternatives and maybe seek the best goals of public procurement, okay? Therefore, Professor Sue said, it's amazing, her speech. I'm not going to talk about GPA rules regarding review bodies, but this is my slide. And I want to give a proposal. I want to maybe put a light on this discussion. And I'm not going through the easier path, which is TCU reliable to get such a position, or we need to give this position for CGU. I'm not going to do discuss about this. It's the easier to solve it. So I'm going to take Professor Carlos Arisson-Feld. He's a study professor at FGV. He coordinates the research group with me at FGV. Well, in Brazil, he's a well-respected personality and also academic. I'm going to present his proposal, and based on his proposal, I'm going to adjust considering GPA's rules. So first, his proposal is to create a brand new kind of agency, independent agency, affiliated to Congress, and not on the executive branch, on Congress, which is National State Council. So basically, the constitution would be amended to say that this agency is supposed to address the following issues, important issues on public management, but especially for our debate here, public procurement. And what this institution is supposed to do? It's supposed to make a kind of rulemaking, as Professor Stevens said before, parameters, rationalize it, and inform it with the database, this rulemaking to issue interpretative rules or legislative rules. And what's the importance of these rules? It's going to reduce this split, this conflict of interpretations, because it's binding to all public administration on federal level, state level, municipal level, all kind of public administration, from companies, state-owned companies to independent regulatory agencies. It's binding all, and also binding all the courts on all levels, federal level, state level, okay? So it's very important for legal certainty. Moreover, this National State Council is under review of Brazilian Supreme Court, Brazilian Superior Court, and Congress regarding of the issue. And one another thing important is that there is a kind of, let's say, the board is encompassed by a president representing AGU, and also 8 others members. Just so sorry, I need to check one message I received here by chat. Okay, so they are representatives of that institution I said before. So they are encompassed on that institutions. And the project deals also with the quality of these people. So they must have a good reputation, they must have 35 years over, and they must have notarial or administrative knowledgement, legal and administrative knowledgement, okay? So this is my proposal. What's my proposal? That this special review board, in accordance to GPA, makes part of this new institution, the National State Council. It's a part of the National State Council. Therefore, the National State Council is supposed to receive requirements, demands from executive initiative or by supplier challenger. And it's important because if this agency recognizes it's something important, maybe it can work in order to have a regulation or to have this interpretative rule that's going to bind all of the institutions and in accordance to GPA principles. This special review board must have the power to engage on agreements to settle. And if it does not, if it can't settle and needs a remedy, for instance, this special review court is going to issue a preliminary decision. Therefore, this process becomes a simplified process and the court to have the final word about it. First of all, this process is interesting because it's going to be timed fashion, and also it's going to be simplified, and it's going to determine the extent of the judicial review. And basically it's upon the due process of law, and also to determine if there is no evidence contrary to the text of the law. What's important to say, we must believe on deference on such issues because we're dealing with a specialized body. Otherwise, what's the reason to say that we're going to have this specialized body and the court can get any resolution once we have? And the judicial decision is going to be extremely important because it's going to have this effect for all institutions. And then our system is completely tied because, for instance, federal prosecutors can only be tied by judicial decisions. So this is a new action, a new process that the law must confer us in order to resolve this problem of coordination. And my perspective is to create this National State Council on the terms of Professor Cardoso, have a specialized body, and comply with judicial review with deference just to have this final decision that is binding for all the institutions, including the federal prosecutors, for instance, okay? So this is my last slide. What I want to say here is that I have an optimistic view. I think it's something extraordinarily good for Brazil. We need to have more experimentalism. So this is not a final confirmation, a final design. This is just a preliminary design. We need to work and see what are the results, if they are positive, and what are the problems. As Professor Stevens said before, that US has this, let's say, this baggage on experience. And moreover, I once again say about the whistleblowing conflicts and whistleblowing reports. In my perspective, this institution is aimed at receiving these whistleblowing reports, basically and mainly from international competitors. So if they want to get into the Brazilian market and they see there is a cartel, they're supposed to have protection against retaliation, and they're supposed to get incentives to report. For instance, they can buy on their own. They can give their own offer without any kind of other offer. This is going to be amazing for Brazil to detect corruption with proofs, with evidences. So that's it. Thank you very much for the opportunity. It's all my pleasure. Thank you.
Thank you very much, Juliana. It was very clear, your presentation, and poses an interesting view, an interesting proposal on the mechanisms of tackling with GPA rules enforcement, and another problem we have in Brazil, the corruption. That is a symptom of a low trust society in the concept of Fukuyama. And we have to tackle, and this is the challenge of tackling with both problems, dealing with corruption and adapting to GPA rules and opening the public procurement market. And one step for this could be an extreme open and transparent information and markets. And with this idea, I will call Lindsey Marchessault, that is Director of Data and Engagement at Open Contracting, and she will give us, will present us a different perspective considering the idea of open contracting and standardization of open data. That is essential for tackling with corruption and other problems that arise from procurement disputes.
Thank you so much. And thank you so much, everybody, for including me in the conversation today. And yes, my topic is going to be a little bit different, but hopefully complementary to what my co-panelists have already shared. So what I'm going to be talking about today is open data in public contracting. So how to publish information and be transparent about public contracting, and how that can actually help with compliance with the WTO's GPA. So to do that, I'm going to start by talking about why public procurement matters and what makes a good public procurement system. And then I'm going to talk about measurement. How can we monitor our procurement system, and what role does data play in that? Kind of building off of what Professor Schooner was saying earlier. And finally, I want to dive into how the Open Contracting Data Standard is an international tool that can be used to publish structured information about public procurement, and how it can be used for analysis and for reporting to the GPA. And finally, I'm going to touch on the tools and support that are available. So it should come no surprise to people who participated in 11 webinars that public contracting matters. But I just thought it would be worth reminding the scale of public contracting Some recent research has totaled the global value of public procurement each year spent by the national governments around the world at 13 trillion US dollars a year. So we're talking about astronomical sums of money that, if used well, can deliver economic prosperity, good services, high quality of life, economic empowerment, equity, inclusion, sustainability. But if misused, is a very much wasted opportunity. And unfortunately, according to the OECD, public procurement is still government's #1 corruption risk. And a recent survey from a couple of years ago found that 57% of foreign bribes were related to public contracts. So there's still a ways to go. And just to kind of bring it to our current context, the COVID-19 pandemic emergency over the last 4 months, 6 months actually, time is flying, has really revealed the weaknesses in our public procurement systems. Because when the crisis struck, governments had to scramble, and the systems were not prepared to coordinate the supply and demand shock. And we've seen widespread abuse of emergency procedures. So people are buying more quickly with less coordination, with less transparency. And that's resulted in, ventilators that never arrived, test tubes that turned out to be soda bottles. And I even saw a case where a $6 million ventilator contract was awarded to a raspberry farm. So, this is serious stuff, and we have an opportunity to make a difference. So we've talked about some of the challenges with public procurement. What makes a good public procurement system? Well, this is something that we've also done a lot of surveying of the international community around. And a lot of people agree on kind of these big 4 ideas of what makes a good public procurement system. Usually people will say right away, value for money. We want our taxpayer dollars to be well spent and to get us high quality infrastructure and services. They also, as related to that, want the process to be efficient. Nobody wants to take 2 years to award a contract or to have something delivered. The second thing, integrity. People don't want corruption in the public contracting process. They want that their bids will be treated fairly, that they'll be paid on time, that there's not going to be any misuse or abuse of the system, that the money that's supposed to deliver a school or a road will deliver the school or the road and not deliver wealth into, private pockets. The people also say it's very important to have that effective service delivery. So yes, as I think someone was saying earlier, the contracting process doesn't end when the contract is awarded. It ends when the contract's completed and we get the thing that we paid for and that the services are delivered to the citizens. So that's really important. And there's many countries around the world where effective service delivery is far from guaranteed. So monitoring that is critically important. And then finally, the business. I mean, the public procurement, that $13 trillion is going from government to business. They have a role in this too. And it's important for them that the process be fair and equitable and inclusive so that it's open to everybody, including women-led businesses, including small businesses, including minority-led businesses, that public procurement is somewhere that private companies have an opportunity to do something for the public good, but also pay their employees, grow their companies, and have some local economic empowerment out of it. And these are all very much in the spirit of the GPA and what the GPA is trying to deliver for its member countries. And just in terms of the evidence for why these things are important, there was another World Bank survey a few years ago of 34,000 companies in 88 countries, and they found that competition was higher and kickbacks were fewer and smaller in places where there's transparent procurement, where there's independent complaint procedures and external auditing in place. And personally, I've seen over the last 6 months with COVID that the systems where these elements are in place have actually been more effective in their COVID-19 procurement as well. So we've talked about what we want, but how do we get there and how do we measure whether we've got it? So the best way to do this, of course, is actually with data. You can survey people, you can ask their opinion, but it's very powerful to actually look and say, well, how many contracts have we awarded? Who have we awarded to them for? How long did they take? So there's actually a variety of indicators that we can use to monitor the performance of those 4 ideas I shared earlier, using very specific calculations, very specific data. And this information can also be used to conduct investigations. So, for example, speaking of cartels, in Bogota a few years ago, they actually used their open data to investigate cartels in the city's school meals program. So these were the companies that were providing the food for the children. And there was a cartel operating. The prices were, more than 20% over market rates. There was frequent shortages. This meant kids went without food or sometimes had spoiled food. So by investigating and detecting these cartels, they were ultimately able to take legal action, to retender the contracts, and now they've saved more than 20% on the cost of their school meals over previous years, and they've had much less instances of shortages or food spoilage. So taking it back to the international level and the GPA, which is the focus of today's conversation, it's important to remember that the GPA has some transparency obligations and some reporting obligations as well, including some statistical reporting. So participants in the GPA undertake to share some statistics about which departments how many contracts each department is awarding, which goods and services are being purchased. And a lot of the statistical information is a major challenge for GPA countries where they don't have good systems for data collection and publication in place. So that's one of the things that we wanted to help with. So my organization, the Open Contracting Partnership, we've developed a tool called the Open Contracting Data Standard. And this is a framework to help publish standardized information about public procurement. And we've created a special profile for the GPA so that if you want to make sure that you're collecting and publishing the data needed for the GPA, you can follow this tailored and specific guidance. But it's important to remember that the reason for open data and the reason for standardized data is not just for the GPA, that it has all of those other benefits that I mentioned earlier. So the Open Contracting Data Standard actually enables collection and publication of information at all stages of the public contracting process, right from the planning all the way through to the end of the implementation. And it basically prescribes how that information should be structured so that it can be used to easily prepare statistics, to prepare visualizations, to prepare web interfaces, apps, alert services, you name it. I've given a couple of screenshots here from different countries who've used the data for everything from fraud detection to their GPA reporting. So this is something that can really help to improve transparency, but also improve accountability if it's used for monitoring and investigation purposes. So if I want folks to remember one thing, it's that the Open Contracting Data Standard makes it easier to fulfill the WTO GPA publication requirements. And it also makes it easier to track the useful market intelligence required by the agreement. So that burden of collecting all that statistical information to share with the GPA is removed. You have that information, the data set is published, and you can quickly and automatically generate those statistics. So just to show this, to demonstrate this, Australia as a publisher of the Open Contracting Data Standard and a GPA member country. So we use their data to generate their GPA reporting requirements. And this is just an example of the total amounts of contract per department. And all of this is very automatable. Here's another example from Ukraine where they actually went a step further and built a dashboard. So they have real-time reporting of their GPA statistics. So of course they can send it off to the GPA at any time, but they can also use it for their own business intelligence to understand how is their procurement market performing and where are the areas where that might require some policy intervention. And again, the Ukrainians make it look easy, but I have to say most countries really do struggle to comply with the transparency and reporting requirements of the agreement because information might still be on paper, it might be in spreadsheets, it might be in different systems. You might have the Ministry of Finance might have some data, the Ministry of Planning might have some data, the different sector ministries might have other data. Infrastructure might be separate from goods, works, and services. And to bring it all together really requires that step of standardization to say, okay, the information that lives over here is connected to the information that lives over there, and we need to bring it together to get that complete record. And open data allows procuring entities to avoid these hurdles and basically lets you eliminate the burden of manually tracking statistics. And using the Open Contracting Data Standard will help to collect and publish the information with ease and empowers you to pursue the GPA's cross-border procurement objectives to see whether the GPA is performing for what your goals are for membership in the GPA. And it's important to note that the Open Contracting Data Standard is a free tool. It's a global public good, so anybody can use it. And again, it's best to use it not just for GPA reporting, but for oversight of procurement, to try to increase business participation and to make procurement monitoring more efficient. In case folks are curious, I thought I'd share some of the countries around the world that are publishing using the Open Contracting Data Standard. And I've bolded the countries that are GPA members. And I've also included some of the GPA member states that have committed to implementing the Open Contracting Data Standard and are actively working on their implementations. So you see we have a great diversity of countries around the world, including European countries, including OECD countries, but also including countries throughout Latin America and even in Africa and Asia as well. So to get started, there are many free resources out there, including the things that I mentioned already, the documentation specifically for the GPA. We also have step-by-step implementation guidance of how you can start mapping the data that you have in your country systems to the international standard and make a plan for publishing a unified data set. We also have guidance of how to calculate the GPA reporting statistics, how to do that automatically using the data. And we also have some special guidance for open contracting in infrastructure projects. As we're having the conversations about the economic recovery from COVID, there's going to be a lot of investment in capital projects, and it's very important that good transparency and governance happen over those projects, and particularly around the procurement of those contracts. So we have specialized guidance for infrastructure projects. And if all of this if you want to work on this, but it seems like you don't know where to start, we actually do provide a free global help desk. Unfortunately, we don't have any Portuguese speakers yet. So if you know any great people, let us know. But we do have the language skills to support in English and in Spanish as a free help desk service. And I've put the email address there. So in case anybody wants to reach out to learn more. Thank you so much. I appreciate your time.
Thank you, Lindsey. It was very interesting, the idea of not only complying with GPA's requirement of transparency, but also to organize and make transparency the rule and in an standardized form is very interesting, is very necessary, considering the volume of procurement in all the countries in Brazil also, and considering also the scene and the situations that were mentioned by Juliana before that could lead to corruption and could lead to some irregularities. And I will try to address some of the questions that were submitted to the panel. One first question that was by YouTube chat. We have a question for all the panelists by Dr. Murilo Lubambo de Melo. That's the following question. In any case, GPA Article 18, Section 3 sets the minimum period of 10 days from the basis of challenge. If a country has cumulative administrative and judicial appeal systems, do both systems need to comply with it? I will. All the panelists could answer the question if you want to address the.
Okay, I mean, I can just address that one. I think the question is, the answer is you have to have some kind of avenue of redress where you have to give at least that minimum time limit to be able to use it. If you had, say, like Steve mentioned in the US, there's 3 different channels, you would only have to make one available that actually complied with GPA requirements. So you could potentially say, well, we have this independent body, it meets all the GPA standards, you have to have at least 10 days from the time you knew of the issue to challenge, that would be fine. But for these other avenues, you have to put your challenge in within 2 days. But I couldn't really see that happening because actually with that time limit provision, it's quite short anyway. But the answer is, as long as you have a system that complies, you could have other avenues of redress that didn't necessarily comply with all the GPA details as well, as long as you have one that does. Does that make sense?
Yeah. And that's a matter of reality too. In most cases, the judicial challenge probably will take more than 10 days in any case. Then this is a kind of practical problem.
I mean, a good example of where you have something that doesn't comply is if you had an option either to go for a procuring entity review or to go for an independent body straight away. Obviously, your independent body review would have to comply with all the GPA provisions. The procuring entity one wouldn't. But as you know, it would be fine to give you a choice between one that does and one that doesn't. Yeah. So it's the same with all the GPA rules. You can have other things alongside them that don't comply as long as you actually have something that does, that people always have a right to go to. Okay.
And any other opinion on this? Okay. And there's a question that was already addressed in part by Professor Sue Arrowsmith from TP that mentioned specifically, Professor Sue mentioned that GPA requirements state that you need to have the right to request access to public hearings, but this could be limited. Presumably, you can set a general rule that would always exclude, for example, all but the largest contracts. What limitations could be allowed? What about something which only permitted this in the case of alleged negligence? But how would you disprove this in advance, or where you were claiming you had a lost contract and not just loss of a chance? And I don't know if Professor Sue want to complement the answer that she has already made.
Yeah, I'd like to say something because I think this is just raises, actually, though it's quite a specific question, it does raise a quite important point that the GPA, you know, the rules are quite not vague, but you can't always immediately see exactly what is and isn't okay. Now, if you have a system like the EU, you have a lot of judicial cases at EU level, which over time clarify this kind of thing. But you don't really have that in the GPA. So there are a lot of issues where there's a lot of uncertainty about what specifically is required. And I think, you know, the answer is often that what actually matters is that the other parties, when you join the GPA, are happy with what you've done. And that's essentially where those questions get decided in reality, is that you will, you know, take it to the other parties. You want to join the GPA, you say, this is the system we have, and they will consider whether they feel that's adequate. So that's, you know, you don't have, I would say that quite a lot of countries do things that perhaps don't really comply, that nobody ever really picks up on, because you don't really have this kind of continuous case law going on like you do in the EU. But on the specific question, my view would actually be, well, you have to have a right to request it. I think that implies that every individual supplier has to have a right to request a public hearing in their particular case, and that the review body would have to look at that and consider it. That would be my interpretation of what that actually seems to say, that they would have to look at all the circumstances. So that would just be a quick answer. But as I said, there's no real material I can draw on to support that, if you like.
Okay. Any other opinion or comment on this question? Then I will propose another question to Juliana that was discussed in the chat too, about the whistleblowing mechanisms that she has proposed during her presentation, and that Professor Steven Schooner has mentioned that an effective whistleblower mechanism is very, very important. It's very, if properly designed, is very important to the system and to the control and enforcement of GPA rules in any country. Juliana, could you explain and more on this topic?
Yes, I could talk 1 month about it, and it wouldn't be enough, but just highlights about whistleblowing in Brazil. So first of all, now we have a law saying that all public administration must have whistleblowing programs. Is the anti-crime law from 2019. And what's the main point here? The main point here is that this is a tool well used around the world. So for instance, US has a huge let's say, experience with the whistleblowing, and it works. It works because, first of all, we have a person that is inside of that scheme, is not involved directly on the fraud, but has a knowledge of this fraud, and it's going to provide valuable information and evidence for the authorities. And this is going to overcome the problem in Brazil of investigation. And it would take a lot of time, it would take a lot of money and a lot of effort to get to that result. And most of the time, we wouldn't get to that result involve a cartel, especially sophisticated cartels in Brazil. They are extraordinarily well done. And if you don't have insider information, you're not going to have evidence and, let's say, tips to address this problem. So in terms of legal boundaries, we have now a legal fundamental for this whistleblowing program. In terms of incentives, we have all the possible incentives with the GPA. So my proposal here is that any company, and especially international company that want to get into Brazilian market on a bidding process, if it takes advantage that there is a cartel, is supposed to report with a protection and also with incentives. So I'm not going to talk only about the percentage of the recovery assets for a government. I'm going to talk about incentives on the process itself. So for instance, this company by itself, without any other one, can make a bid. So that's an extraordinary advantage for our system. So in my perspective, we don't need a special rule, a law from Congress. And it's something that on the administrative rulemaking can be addressed. And it's extraordinarily important in Brazil. So why car wash was something extraordinary? Because there was inside information, not on whistleblowing program. It was a different program, a correlative program of leniency on the penal or the criminal law. But the main tool was the same, inside the information. So, I mean, what I want to say is that this is something we need to tackle, and this would be a totally effective change on the way Brazil struggles with corruption. Just remembering that I'm talking about cartel. I don't think it would be enough, it would be sufficient, or Brazil, a developing country, would have the money and the skills to receive all kinds of whistleblowing reports. That's not the main point. The main point is cartel, which is extraordinarily difficult to reach and has a potential impact on the market and our credibility internationally.
Okay. And as we, any other comment, any other opinion on this matter? As we are approaching our time limit, considering our schedule, I want to thank to all panelists for their time, for their generosity in sharing their thoughts on this important matter. And I will open for everyone to make final comments if you want to.
Well, I almost never give up the opportunity to make a final word. So I just want to reiterate the point that I made earlier, is that the accession process to the WTO's government procurement agreement is long and it's arduous and it requires research. And I think there are significant returns on investment. But at the end of the day, it's entirely focused on procurement process. And while there are many benefits of that, it's important to keep in mind why we do procurement in the first place and to ensure that we also focus on our procurement outcomes, because the process itself, maximizing transparency, ensuring competition, having an open regime, is not going to ensure that you get the goods and services you need. So focusing on outcomes by focusing on important data matters. Staffing the process, particularly after the contracts have been awarded, is incredibly important. And remembering at the end of the day that procurement and contracts is all about people, and managing relationships is difficult and it's hard work, and you have to invest in it and constantly make sure that you're trying to upgrade everyone's skills. But in any event, good luck. It's very, very challenging.
Yeah, if I could just sort of add to what Steve has said, I mean, the EU has gone through decades of focus on process. The EU system has been very much focused on this kind of process, you know, having your competition, how do you conduct your competition? It's only in recent years that the European Commission has started to realise how important the other stuff is and start trying to encourage countries to look at these other aspects of procurement, like professionalism of the workforce and so on. So yeah, I would just reiterate that and say that, you know, that is now getting more focus in the international arena as well. And it's very, very important to look at that right from the start and not just to see this as a process tick box going through the rules, but to take the opportunity, the political opportunity to look at public procurement in a much broader way.
So I just want to say thank you for the opportunity. It was an honor. And also to say that we must integrate the GPA debate on the ongoing agenda of reform in Brazil. We have administrative reform going on. We have a public procurement reform going on. So why not integrate all these agendas and think in a unique solution aimed at the future? So it's not a solution for right now. And moreover, it's extremely important to have an independent reflection of this reform and not a reform aimed at one institution or another institution or based on one kind of culture instead of the other kind of culture. It's extremely important to consider our problems on data, contemplating here all the previous amazing talks, data, and also experience from other countries, and also our cases. We need to have well-sophisticated reflection, and I invite this integration of agendas. Thank you very much.
Thank you, everyone. This was a pleasure. And if anybody wants to discuss these topics more, I'd be happy to have a follow-up conversations with partners in Brazil about procurement reform, open contracting, data, and all these wonderful topics. Thank you so much for having me.
Thank you very much for all our panelists of today's webinar. And I thank also all the attendees that were watching our discussion. And I invite everyone that is interested in the matter to watch the previous webinars. As we mentioned at the beginning, we had 11 sessions of discussions on different and important topics of the assessing of Brazil to the GPA rules. And all these seminars, all these webinars are recorded and are available for free for everyone to access on the YouTube channel of IDP. And thank you very much. Thank you.